Yeah. Is this better? Aha. Oh, my goodness. I feel like Madonna. Good morning again. Welcome to the program on patent law and global competition, economic competition panel. We welcome all of you. We have a very interesting and distinguished panel, and we're going to try to leave time at the end for questions. So if you have them, we'd welcome them. Before I do introductions, I'm interested, how many of the people in the audience are lawyers who practice patent law, either in the United States or in Russia? A few, okay, all right. And how many of you are working in ministries of governments? Okay, all right. We're going to try to make this practical for the lawyers, and we'll do some policy for the ministers. We're honored this morning to have with us the new Chief Judge, Chairman of the Supreme, the Russian Court of Intellectual Property. Her name is Lyudmila Novosela, and she is going to be with us until 11 o'clock this morning. She has to attend a funeral of a very prominent member of the bar in Russia. She has over 30, 40 years of experience in the law. Prior to this position, she was the prior judge of the Superior Court of Commercial Court of Russia. Her subject matter expertise included civil, corporate, bankruptcy, financial transactions, and she was a member of the Russian Federal Common Commercial Court for Codification and Improvements of Civil Law. She's the author of over 130 monographs, and we're delighted to have her with us. And we also have her colleague, Igor Drazdova, who is the Chief Counsel for the Skolkola Foundation. And we're delighted to have him as well as our guest. I thought we might begin, I will introduce the U.S. speakers as we begin to move to them, but to begin with some comments about how one gets a patent in Russia. What's the process?
Уважаемые коллеги.
A very good morning, distinguished colleagues. I will speak Russian, even though the majority of the panelists here are English speakers. Regarding the process, the patent process in the Russian Federation, I perhaps will provide just this kind of reference. Issuance of patents is taken care of by the federal agency, which is called Rospatent, which is the Federal Agency for Intellectual Property Rights under the auspices of the Ministry of Economic Development of the Russian Federation. And patents in Russia are issued for such things as inventions and useful models. And the issuance of patents for those in Russia is different from practices in other jurisdictions. And between themselves, those two processes also differ. Inventions involve two kinds of expert evaluation. One is formal, and the other one is evaluation in essence. In terms of the models, the situation is different. There is only the formal expert evaluation, and notionally we can say that in this case it is mostly done in a form of a notice. That is, useful models or utility models do not mean that one has to verify all the technicalities which are relevant for patentability issues. Well, basically, patents issued in Russia are much less in number as opposed to what we see in the States, and we're lagging behind to a degree, if I can use this wording. But respectively, the issues which arise out of that are much less numerous. As far as I know, in the US patents bodies, there is a very long queue of applications and claims, and it takes a lot of time to have the patent issued. Now the situation in Russia is different. Perhaps I will not be 100% precise, but as far as I remember, on an annual basis, we see about 30,000 applications for patents, and out of that, 1,000 are international. That means that those are done under the PCT system. That's only 1,000 for the entire state of Russia, and this is negligible being compared to practices and situation in many other countries. And of course now Russia pays a lot of attention as to how this area can be developed. We look at the experience which is available in China now. China has made quite a big progress in this area. There are still, though, accusations towards China in terms of infringements on some patent laws. On the other hand, China takes very active measures to protect intellectual property rights, and as far as I know, volumes of patent works with Chinese companies are about the leading in the world in recent times. I will not detail now as far as the procedure is concerned, and the one which is used in the patents bodies in the Russian Federation. I believe those would be very much similar to the processes and procedures which one can find, well, at least in Europe, and there are no principal differences, even though there are some nuances. In terms of comparison with US practices, and we see that on a routine basis, well, we know that IT solutions and everything which concerns with IT area is subject to active patent activities and account for a major share in the total volume of patent work. In practical terms, even though some do not believe it is an issue, but still we do believe that it's a challenge because there are, such things as patent trolling, and there are disputes in courts of law. Those are also the issues that Russian companies face, for instance, when they try to penetrate the US market. In Russia, this is not yet an acute problem due to one simple reason, that we don't have as many patents. And solutions in the IT area are not subject to active patenting. There are differences, though, in the legislation between the two countries, which narrow down such opportunities. And, well, objectively, our applicants are not keen on doing that, even though within the Skolkovo Foundation there is the Center for Intellectual Property, which provides services in the area of patenting. And I can say that we do pay close attention to IT patents, and that testifies to the fact that basically in Russia too, one can, to a degree, work with patents in the IT area, but this is not very well developed. Just in terms of example, in 1 year's time, our center accounted for about 20% of all the applications nationwide, and that just testifies to the fact that patenting in the IT area is underdeveloped yet. That is in a nutshell.
We're fortunate to have David Kappas with us here. David was a chief intellectual property lawyer for the IBM company before he was chosen by President Obama to be Undersecretary of Commerce and the director of our patent office in the United States. I think it's fair to say that he modernized and revolutionized and energized particularly our patent system, and I know many of our people there in Washington are sad to see that he's now gone back to the private sector. He's practicing in Cravath firm in Washington, D.C. But David is really a good example of really a shining star in our government, at least, in the patent area. And he will talk a little bit about the patent process in the United States and a little bit about the new legislation in the United States that he was instrumental in getting through the United States Congress. David?
Well, good. Well, thank you very much, Judge Braden, and good morning. It's a pleasure to be here in St. Petersburg, a very beautiful time of year and a very beautiful city. So let me just talk for a minute first about the United States patent system. A couple of comments. The U.S. has what's called invention patent system, in addition to a design patent system, and receives at our United States Patent and Trademark Office somewhere in the neighborhood of 450,000 patent applications a year. Also, of course, a big trademark office in the U.S. that receives about another circa 400,000 or so applications. And in the U.S., we have that single agency that handles all of those intellectual property matters together. Our system in the U.S. is constitutional in nature, in that from the very beginning of the United States government, back in the late 1700s, a clause was put in our original Constitution that called for protection for inventions, and that was the clause that led to the patent system and the creation of a patent office, actually under Thomas Jefferson's leadership, the first U.S. Secretary of State, and starting in the 1790s, and an agency then that was created and has been around now for well over 200 years. So the U.S. also has, because of our cultural background and the history of our country, had from the very beginning a very, very strong patent system, strong trademark system, also strong copyright system, strong general intellectual property system, on the belief that strong protection for intellectual property will lead to strong incentives to invest in innovation, which will lead to more innovation and more opportunities for people in our country and everywhere. That's sort of the cultural background that gives you a sense for why the U.S. has the kind of system that it does. So the U.S. has had this very strong set of property rights in place for a long time. What comes with that is a need for constant adjustment as new technologies are created, as changes occur in the marketplace. And the way that's worked in the U.S. is that our Supreme Court and our Congress have taken up leadership consistently for actually centuries in enabling our system to accommodate new kinds of innovation. So you think software innovation. Many other places in the world, it's either not patentable or patentability is extremely restricted. The U.S., we've taken an approach of being relatively open to patenting of inventions that are implemented in software. The same thing in the biologics, the biology field, where the U.S. has taken a position historically of permitting a rather expansive protection in that area. So what that leads to is a need for lots of adjustment as technology develops, as the strength of the system comes up against the need for active protection of the public's interest also in having access to technology. And what that's led to most recently is the America Invents Act, which is a piece of legislation that our Congress passed in 2011, was signed into law by the President in September, and did a number of things to ensure continued balance in the U.S. system. Very importantly, it created an extremely robust set of post-grant challenge procedures, including a post-grant opposition procedure, an inter partes review procedure involving certain patents relating to business methods. and other procedures that provide a backstop on the patent system and enable parties to bring patents that have been issued back into the expert agency, the USPTO, to ask the agency to take a second look at them and either confirm the scope of the claims or adjust them as needed. And so the AIA has created this very robust backstop. It's been in place now for over 6 months. There have been several hundred of these new processes filed. The system is very much coming up to speed in terms of people using it. The AIA also represented an effort by the U.S. to update aspects of its patent system to accepted international norms. Most importantly, the move to first to file. Now, Russia and many other countries have been first to file countries. In fact, the whole world was on first to file, except the U.S., but the U.S. is now also through the AIA, which moved us to the same essential system that you're on. The AIA included other improvements as well that take advantage of the internet era. For instance, the ability of third parties to submit prior art and applicable commentary electronically over the internet for free that goes directly into the appropriate examiner of the USPTO's 7,000 plus examiners to enable that examiner to have access to the best prior art, most applicable commentary from anyone in the world, including people in Russia who care to get on and submit prior art on published pending United States patent applications, and everyone else in the world who wants to do that, enabling our examiners to do a really, really thorough job on examining patentability. There are other provisions of the AA. I won't go into all of them in detail. We can talk about them later if there are questions and comments, but the overall view you should know about that legislation is that it provides very powerful backstop to the patent decisions that the agency makes. Those are the post-grant challenge provisions. And it significantly updates the U.S. patent system to the internet era and international norms. The last thing I'll mention is the PCT and the Patent Prosecution Highway. So the PCT, the Patent Cooperation Treaty, is the international system of procedural norms administered by the World Intellectual Property Office, a branch of the United Nations headquartered in Geneva, Switzerland, that enables patent offices, including ROSPAT, including the USPTO and other offices, to have a common framework that we use to procedurally accept patent applications. The PCT is a very powerful instrument. Of course, the U.S. Is a receiving and examining office, and in fact, I think remains the largest participant in the Patent Cooperation Treaty, with many tens of thousands of patent applications received and handled under the PCT every year. The PCT, however, is a mechanism that benefits from another form of procedural coordination, which is called the Patent Prosecution Highway, which was a system that created by the JPO, the Japan Patent Office first, that enables patent offices to interlock very effectively, trade information, and to cut costs and speed up the time in which they examine patent applications. And the U.S. has been a big supporter of the PPH. The U.S. has, I think, 25 or so PPH agreements, each bilateral with other patent offices, including with Rospatent here in Russia. The U.S. has processed now, as I understand it, over 16,000 PPH entries, some here in Russia and many in other countries, that have enabled patent applicants from your country and from others to save many millions of dollars and get very fast patent processing in the U.S. and enabled U.S. applicants to do the same thing here in Russia and other countries. So the takeaway for the PPH and the PCT is that they represent powerful global patent harmonization vehicles that operate on a procedural level, try and enable our patent offices and patent applicants to operate more effectively, to reduce costs, to speed up processing, and to try and weave together our national patent systems into a kind of a global patent law framework or fabric. Thank you, Judge Braden.
Thank you, David. Could you comment on your experience with these two particular international treaties?
Если говорить о
Now, speaking about PCT system, indeed in Russia it is being used quite extensively and actively. Russia is involved in the process. As I mentioned before, the international applications under PCT system are filed through the Russian patent system. It's an efficient and feasible mechanism, but it is not being widely used in Russia. It's not about the drawbacks of the mechanism itself, but many of the Russian applicants simply don't know whether they can reach the international markets, and they don't know whether they need a patent at all for that. And some of the applicants are carried away by the high payments and costs that they have to pay in other countries to support their patents, and these are much higher than the Russian local costs. But overall, we as a country and all of us in this business are trying to push forward this idea of the need to file a PCT application for a patent. There's a much more convenient way rather than having subsequent and parallel applications for patents in different countries. Now, speaking about the second mechanism, PPH, well, I personally did not deal with this system, but I discussed this with Boris Simonov, who is the head of the Russian Patent Office, and he shared his opinions with me. And he is very much enthusiastic about this, that there is such a system in place now, and the Russian Patent Office is now interested also in working under the PPH norms with a broader number of patent administrations. But it is important to have such trust between the patent administrations. You need to be trusting other patent services abroad. I don't know whether it is being used also extensively in practice between other countries, and whether maybe David can explain that. But indeed, the results of an expert examination that are issued by the Russian experts perhaps can be accepted without any rechecking or verification by American experts. I don't know whether it is true or not. I know that there are some there is some professional competition involved, of course, because experts of each particular patent administration would think that they are more competent and skilled in checking information. For example, if in the US there is such an agreement between Russia and the US, as far as I know, but it is more hard-going between Russia and the European Patent Office. So I think that this is more of a global challenge, and it is not peculiar to Russia alone. And of course, for PPH system to work efficiently, we need to realize that patent offices work with more or less the same databases, but there are different databases to search and to search information, and there is not really a close match between the databases. Also, there are some language peculiarities. Some information is only available, for example, in Russian, and such information has never been translated, and there is no access from other patent administrations to such information. And this is also true of other less widespread languages, which of course makes it more difficult to have such a universal database which would be universal and would be equally accessible and used by all patent services. Something to think about. But overall, the attitude to the PPH system is very positive, and I think it holds for the future. Thank you.
Great. Now, you realize that all of the work that they do is the issuance of the patent, hopefully a valid patent, but it's up to the judiciary, to the courts, to decide other important issues in terms of infringement and what the consequences of that are. Before turning to Madam Justice, I'm going to ask Phil Johnson, who is the head of the Intellectual Property Department at Johnson & Johnson Company, which has a substantial presence here in Russia, to explain briefly what the different processes are in the U.S. system when someone files a complaint and says, my patent has been infringed.
Thank you. It's a pleasure to be here. It's a beautiful city, and I'm delighted that we could all be here to talk about this important topic. It is true that once you have a patent, the patent is only as worthwhile as it is if it's respected, either by private agreement or in the courts. And very often, most patents in the United States and elsewhere are respected. And fortunately, most patents never end up having to be asserted in court. In the United States, the percentage of patents that are respected is somewhere around 99%, and about 1% of the patents do end up entering a court proceeding at some time. We have courts that are state courts, that is, for each individual state or province, if you will, has its own set of courts, and patents are not litigated in our state courts. They're exclusively litigated in our federal courts. That is the set of courts where there's a trial level, we call the district courts, and one single appellate court is where all of the patent matters go, and that's the United States Court of Appeals for the Federal Circuit. And that, for most patent cases, is the last court, but very occasionally the Supreme Court of the United States will grant petitions to hear patent cases, and they've been doing so in greater frequency in the last year or two. For many years, they took almost no patent cases, but now, recognizing the importance of patent matters, the Supreme Court has been taking 1 or 2 or 3 patent cases a year. So it's a matter of great attention in the United States how patents are being treated when they're brought for assertion in the courts. In our system, juries are used in patent cases in about 70% of the cases. And so you file your complaint with the court. The accused infringer has a chance to answer. Discovery is taken. Discovery meaning discovery of information that the other party has or that third parties have about the patent and about the infringement, including discovery about what was known anywhere in the world that might invalidate the patent. So validity is very much an issue in these cases. Under the new AIA, under the new patent law, it is now possible that the validity issues may be deferred from being heard in court and sent to the patent office in an inter-parties review proceeding, which should take about a year, maybe longer with an appeal, so that the validity determination may be made in the patent office. But in any event, the issue eventually returns to the district court, the trial court, and the trial court will eventually schedule and hold a trial in front of a jury of people chosen, members of the public, who will hear the case and who will decide the facts of the case as to whether there was an infringement, whether in their view the defendant was able to show that the patent is invalid, or that some other defense should mean that the plaintiff, the patent owner, will not prevail. These trials take about 10 days on average and result in decisions that are reviewed by the district court judge, and then if they're upheld, may be appealed to the United States Court for the Federal Circuit, the Court of Appeals, and they will consider it in written motions, written arguments, and that will take about another year. So the process is a several-year process, and assuming there are no remands or other possible sidetracks, and it is considered, I think, an excellent process by those of us who use it. Unfortunately, it's not inexpensive, but the matters that are heard by these courts are considered to be very important. Not only in terms of the dollar amounts that are awarded, which now may range up to $1 billion or more, but also in terms of the orders that are given as to whether you are allowed to continue to make a product or whether you have to stop making a product.
Thank you, Phil. Two minor points just to add to Phil's explanation. Most of the judges of the United States are generalists. They are not, at the trial level, they are not judges with specific expertise in patents or in technology. Also, our juries, by and large, the people that are chosen for the juries do not come with specialized expertise. So you're getting generalists looking at specialized and important technology, and legitimate questions have been raised in the United States about how such important questions can be answered by people that have a generalist background, unlike the system certainly in Europe and other places. In the United States, to address that, there is recently something called a pilot program. So in the district courts in the country, for instance in California, in New York, and some of the other places where they have more of the patent cases, the judges on the district court who have had patent cases and have some expertise have volunteered to take those cases. So it's an experiment to see whether or not the quality of the decision-making will improve in the next 10 years while this program is underfoot. It's a voluntary program by the judges, and we will see there will be a report given to our U.S. Congress each year about the progress of that particular experiment. I haven't introduced myself, but I'm a judge in the United States Court of Federal Claims. I am like a district court, except I only hear specialized matters against the United States government. So all the cases in my court are concern the United States. I have patent jurisdiction in my court. And so typically, I'll give you a good example that I use often. I had Honeywell is a big US company, and they claimed that they had patents on night vision goggles, night vision technology that's used in the military. So they sued the United States government for infringement because the United States was purchasing aircraft from Lockheed Martin Company that utilized technology that was made by L3 Corporation in the aircraft. So it's a matter of using the technology. Because they were flying the airplanes, they were using the technology, the government was sued. And I found that Honeywell had established liability infringement on certain claims, not all the claims that they held, and issued a money damage award against the United States government. Then the government, in turn, usually has indemnification agreements with the manufacturers, and so they then say, well, you now reimburse me for that. Another interesting case that I have, just to give you the breadth, is the McDonnell Douglas family has alleged that they did not transfer all the patent technology in the stealth bomber to the Boeing company, and that case is pending before me now. So they're big, they're very interesting, and they're very big cases, but they're all non-jury trials before me. Now, I consider myself a patent lawyer, but I did trial work in intellectual property, primarily with computer software, but I did do some patent work before the International Trade Commission, before I came on the bench. So I do have some background in that area, more so than many of my other colleagues. So tell us, Madam Justice, about the new court that you are going to be heading here in Russia. It's very exciting and important. And by the way, I was fortunate to have attend lunch with the Prime Minister, and I complimented him on your appointment specifically and the appointment, beginning this new court.
Спасибо, Сюзан.
Well, thank you, Susan. Let me just make a very brief presentation of our new court, and then perhaps pay your attention to some of the challenges that we are facing in this area of regulating patent rights. Indeed, the establishment of a specialized court is a very timely move. I think that this project would offer better litigation and consideration of the protection mechanisms in the area of intellectual rights in general, not only in terms of industrial patents. We have broader powers, I think. We accumulate all claims related to the intellectual property and related to entrepreneurship in the Russian Federation, and it's the only body of appeals for our big country. But since we're talking about patent law, then the court is playing a key role, because it basically is the top instance for the claims that are being filed. My colleague mentioned that the court is built in a way that it considers the decisions of the bodies of patent registration and issuance, but on cases that have already been heard by the lower tier courts in an administrative way. So when we are talking about decisions of Rospatent, the Russian Patent Service, and there is a decision, then this decision can be further appealed into our courts. So we bring in some form of justice into this very specific relationship. But for our court to be able to do its job, we had to implement a number of procedures by law, and we already have a number of very peculiar decisions made which distinguish our court from other courts. For example, in our court we have a group of technical experts who need to provide assistance to judges in hearing cases when judges might have some technical questions which require specialized knowledge. Plus, our IP court can also summon technical experts from the outside or third parties. We send a request to invite such technical experts to be involved in considering the details of a particular case. This is one of the elements which we think may improve the quality of our trials in terms of using specialized knowledge. One other point that I should mention is that the law directly says that in choosing judges for case hearing, if you have several candidates available, the priority is given to a judge with a technical training background So if we have a number of judges with simply legal education, but if you have one of them with a technical background as well, then the preference is given to such a candidate with two educations. Well, of course, we are not able to have all our judges to have a second technical training or degree, but if you judge from the handouts that I provided to you, we have a number of such judges with the second education behind them. So our idea is to offer our judges with the legal training to augment their knowledge through technical training. And I think that this would allow, in many cases, to get rid of the need to involve experts, which is a costly procedure, which also involves a lot of complaints between the patent holders and the people who apply to court for consideration.
Let me skip the details of the competencies of the court and its procedures, because I believe that that is quite technical and could be discussed within a different format of a panel. I would rather focus on some other issues which I believe are important. First and foremost, as Igor Alexandrovich mentioned, in this country we do not have many patents as compared to US and Japan, and respectively the number of disputes in this area, looking at purely patents, is not very significant. Last year, the stats based on the system of courts of arbitration says that the number of such disputes was not more than 70, as confirmed by papers relevant for the patent work. I think it was precisely 63 such disputes. But regarding other categories of disputes which involve the registration of various types of intellectual property rights, I would say that the majority of those relate to trademarks and those relevant for services. The court has heard more than 500 of that, and the number of disputes looked at within the administrative procedure is even more than that. In terms of forecasting, I believe we should have considerably more disputes heard in the patents area, because, among other, the companies, organizations do not yet turn to courts of law because they do not hope to find the adequate understanding and competences there. This was indeed the case until this specialized court has been created, and previously this was a major impediment. So the procedure was that an expert gives an opinion within the administrative procedure, and many believe that it isn't worth it to turn to court for seeking a different type of decision, and would rather agree in any other way between themselves. A very small number of disputes involve compensation of damages which are relevant for infringement of patent rights, and this is a very serious issue which dictate certain amendments in the legislative area. Just one point to note, in terms of providing evidence of damage, if it is some counterfeit products or goods, usually the calculation of damages boils down to the following. We look at the potential profit that the holder of a trademark or a patent could have derived, provided there was the same kind and the same amount of products manufactured to that which the counterfeit party did. But this is wrong, because counterfeit products are cheaper, and it is not certain that the legitimate holder of a right, if doing the same kind of job in terms of volumes and units at his manufacturer's facilities, would have derived the same amount of profit. So as to how damages should be calculated in this case and what the methodology should be is quite a stumbling block now. I believe that this problem can be effectively tackled, and that could be a major step to enhancement of protection of rights of patent holders. To do that, we need to include the provision on the compensation of damages. That is a certain sum which could be claimed without this kind of evidence, and that is what we find for trademarks, but not yet with respect to patents. And I believe that the amendments which are being proposed for the civil code could be very helpful in terms of the situation of protection of rights of patent holders. This is still under discussion, and yet I think that the issue of such compensations could be a major step forward in the development of our system and would generally improve the situation with protection of rights of patent holders. I think that I should finish with that. Just a few words to wrap up. Indeed, we are a very new body. We're the newest ever in the Russian Federation and perhaps in the world. And what we would like to do within the scope of our activities is to capitalize on all the best practices and the relevant experience which is available globally. And because of that, I would like to offer you to cooperate in all the areas that we can think of. And if our colleagues would find it feasible and possible to organize whatever events within this format of cooperation. For instance, we have colleagues here from the highest court of arbitration, because this is our supervisor, and we are doing this job together, protecting the intellectual property rights. So that means that we are open for any proposals in this area. Thank you.
Chief Judge Rader, Ronald Rader from the United States, was supposed to be at our panel, but his plane had mechanical difficulties and it was canceled. But he is planning to come to Russia next year and to bring a number of members of his court and some other U.S. judges. Phil Johnson, in particular, has been very active in working with the Federal Circuit Bar Association. I forgot to mention that you're going to be upcoming president of the Intellectual Property Owners Association in the United States, which is a very powerful entity, and in terms of representing basically major Fortune 500 companies that have patent stakes, etc. And we can always count on David to be helpful, because he and Phil were very active and involved in this American Invents Act legislation, which is very difficult to get through the U.S. Congress. So maybe they can give some tips to try to get you the support that you need in your own country to do the work that you want to do. I think we could learn a lot from your idea of having judges with more expertise in patents. Indeed, that's something that has been discussed in the United States, that we need, particularly at the Federal Circuit, to have judges who have specific expertise in or have some practical background in the area before becoming judges, because the decisions are so important. I would venture to say that that's in case that court, in my judgment, is more important than the Supreme Court of the United States, because of the implications of their decisions to the U.S. economy as well as the world. And the chief judge he's done this he's had formal visits to China, to Korea, to Japan, I believe to Germany, and perhaps I've missed a country. He is planning the next year to go to Russia and the following year to go to Brazil to try to provide a support system and for us to learn your best practices too, as you're learning. I think the system needs to be reinvented as often as different cycles and technology to be relevant. I have promised you to tell you when it's 11 o'clock because I said you have a funeral to go to, right? So we appreciate you being here today and thank you very much, and we look forward to seeing you next year. Thank you. I thought we might turn now to discussion a little bit about international enforcement of patents. Both the United States and Russia are parties to the TRIPS agreement that has assisted inventors to acquire worldwide patents. But the TRIPS agreement does not directly address the problems of international enforcement in a forceful way. I'm curious to what our members might think of I'll go first to the U.S. industry and then conclude with you, and I'll turn to David. First, I'll turn to Mark Kesselman. Mark is currently the General Counsel for PepsiCo USA and Frito-Lay, and hopefully you'll want to eat some of his chips and drinks during the break. Mark has a very interesting background before joining Frito-Lay. He was in private practice in the United States, but he went into the Justice Department, rose through the ranks there. He joined the Bush administration in the White House in the Office of Management and Budget, and then he became the General Counsel of the Agriculture Department. You might wonder, well, why is the Agriculture Department important and what's the relevance to patents? The United States Supreme Court just recently issued an important case concerning patent rights over seeds, concerning the Monsanto company. So Mark, what do you think we all ought to be looking at for international enforcement?
Thank you, Judge Brayton. It's really an honor to be here. Such a privilege to be in Russia, which is a tremendously important country for our company, PepsiCo. So many of you may have looked at the panel and understood why someone from IBM, from the Johnson & Johnson company would be here discussing intellectual property rights, but may be wondering why PepsiCo. So if I could take just 1 second to explain how we fit in and why we care, and I think that will inform the perspective. So as you know, we are the second largest food and beverage company in the world. Here in Russia, we are the largest food and beverage company. We have a number of brands that you probably know and love, including Lay's, Pepsi, Lebedyansky juices, the Wimbledon dairy products. But more importantly, to understand our company, it's to understand that we have 25,000 associates here. We have 40 manufacturing facilities, including the largest Pepsi bottling facility in the world, which is actually just up the road in Dodovienko, I think is the name of the town. And so when you think about what it is that we're concerned about, we're both an innovator, which you may not typically associate with food companies, but we're also a downstream user. So how are we an innovation company? In many countries, we actually own production from seed to shelf, starting with our own proprietary seeds. We have breeding programs all around the world where we like to make sure that when you have a Lay's potato chips, it starts from the best seed with the highest quality potato that's optimized for design for making a chip to produce the best flavor and taste when you open that bag for a delicious product. We all the way through methods of manufacturing which are proprietary, down to the design of products. Someone mentioned that you can have design patents as part of our, in some patent systems, and we actually have designs on product shapes and in packaging shapes. So we think of ourselves as very much of an innovative company. We invest very heavily in research and development. Similarly, we also, when we approach patent policy issues, we're a downstream user, meaning that we innovate in our area where we commercialize, in the food and beverage area, but we also use technologies. So products developed by IBM, for instance, and computer systems and radio frequency systems for our vast transportation network. So we look at these issues really from both sides as an innovator and a user. And because we're in nearly every country in the world, we think very carefully about how we place our innovations in different countries. So if there are, sort of one comment I would make to Judge Braden's question, I would say that it really comes down to when you have international enforcement idea, in the absence of patents being prosecuted under uniform standards by unitary courts, decisions on infringement can be difficult to recognize. So what does that mean? That means that we're a business, and there are certain things that business is like. The first is certainty, where we like to know going into any enterprise what are the rules of the road going to be, because when you know the rules of the road, you can plan accordingly. We also like quality of judgments. We recognize other people's IP rights. We take very seriously the idea of not infringing on other people's patents and other types of IP, such as trademark. And we like to get there in the most cost-effective way as possible. So when we think about investing in an innovation and investing in protecting that innovation, which are two very separate investments, cost is absolutely an issue for us. So when you look at that, and we look at different standards by which patents are reviewed in different countries, that actually becomes a key cost consideration for us. Because a patent which is granted under different standards, I think that one of the prior commenters talked about competition in the sense of competency. And in many instances, it's not a question for us of competency, but rather you might have two very competent patent review officials reviewing patents under two very different set of rules. The standard of what is patentable in a country might be different. The scope of enforcement in those countries might be difficult. The definition of prior art might be different in those countries. And so for the international enforcement, we do look for instances where those standards are similar. And we think that there are opportunities for harmonization of enforcement in that context. And by contrast, I think that it becomes more difficult when you think about different countries with different standards, because in that instance, you want to make sure that you don't have decisions in certain countries that are enforced in one way in which the either standard on which it was granted or enforced in another country was not intended. So to that extent, the harmonization efforts that other panel members have talked about are really quite important.
Phil, I know your company has a big presence here. What are your thoughts about enforcement?
We do have a presence here, and Russia is very important to us now and especially in the future. Our thoughts are that, first of all, we're very pleased about some of the efforts that you're making. We've been involved in the beginning with some of the efforts because we see the issue not just as to manufacturing and distributing products in a country like Russia. We would like to see the products invented in Russia and our product line expanded with new innovative products that are designed to meet the needs of the Russian public. We're a very broad-based company. Our products are used by over 1 billion people every day, and we obviously would like to increase that number, and we realize that the problems that need to be addressed and what people need and want in different regions of the world vary considerably. So we're very interested in moving our research organizations to the places that the countries that we would like to serve. But in order to do that, we have to assess how receptive the local laws are, the local government is, to doing research. And we ask ourselves questions like, first of all, are the people there? Is the infrastructure there? Do we have an interest in supporting science? And we certainly have heard about that, and that's wonderful. And so then the next question is, well, what are the laws going to be like? If we develop trade secret information, which is what you do when you're doing research, will that trade secret information be respected in the courts, or will the employees be simply allowed to take the trade secret information and go across the street and use it for purposes against ours? And there are countries in the world where that is the case, and they are not countries where we tend to establish our research organizations. Then we look further and we say, well, if something significant is invented, will we be able to get protection? And will the protection be worthwhile protection, not only for respected within the country where we get the invention, but we would hope in this example that a Russian inventor's invention would be one that we may seek to protect all around the world, and we would like the systems, the patent prosecution highway and other systems to be able to get that protection so that eventually, if the invention merited it, we would be able to sell it around the world and benefit everyone, from the inventor to the company, for doing that. So enforcement is part of that. And a patent which is granted, which cannot be upheld because it's so easily challenged again in an administrative proceeding that it's worthless, is of no value to us. In the same token, a patent that's granted and is not upheld in the courts is also of no value. So that's not to say every patent that's granted should be upheld, because mistakes can be made, errors of judgment can be made. So we also don't want to be sued by other patents which should never have been granted. So this is the trick of every patent system, is to identify the inventions that merit protection, that are truly deserving of protection, to give them that protection and uphold them, and to, as infrequently as possible, don't award patents that are not deserving, should not have been granted. But that's what we look for worldwide, and that's what we look for in a country like Russia that is paying attention to and working very hard on developing a world-class patent system. China, I do think, is an example. China has been working very hard. They've been very open. They've been collecting a lot of information. I've been going there and others for years, and they know that they're not there either. And in fact, none of us are there. I mean, in the United States, as Dave Kappas mentioned, we just worked on, for many years, on a new patent bill, and we're working on another one right now, this morning. We're getting emails, Dave and I, about refining the patent law in certain of the areas where maybe we didn't cover everything. But it's worth doing, because ultimately there is a lot of capital in the world. There are a lot of problems that need to be solved in the world. And what the patent system should do at its finest is encourage people who have money to invest it to solve the problems that we need to have solved, so that they will be fairly compensated if they find those answers, and we as members of the public will get the benefit of those solutions. And so, I congratulate you for the work you're doing, and I hope your new venture is a tremendous success, and the new court is a great step towards that. So it's exciting to be here.
Before I'm going to finish with you to wrap up this particular area of topic, but as I mentioned before, Mr. Kappas had worked for IBM Corporation before he came to the United States government to work, and your primary interest at one point was in Japan. But can you give us some perspective from your olden days with IBM?
Well, sure. Thanks, Judge Braden. Just a couple more comments relative to this enforcement topic. It is obviously extremely important. The efforts going on with your new court here in Russia are very, very positive. Something that the United States invests in very, very significantly, including programs. Now I'm speaking as a citizen, right? I no longer work in the U.S. government, but just to mention programs going on throughout the world that attempt to work collaboratively with other governments, including the USPTO's IP Attaché program that places USPTO employees in other countries, including Russia. We happen to have the USPTO Attaché to Russia here in the room this morning. The USPTO also has attachés in a number of other countries, Brazil, Mexico, China, among them, not to mention some others. And the purpose of all of these people teaming with like folks in your government and people in the private sector here in Russia and in the other countries where we have our attachés is to achieve some of these goals that Phil's mentioned, that others on this panel have mentioned, about cooperating in order to achieve better, more uniform, more consistent enforcement of the IP laws. And that is where, whether you're in the information technology industry, the IBMs of the world, or whatever other industry, you benefit from, the country benefits from, society benefits from consistent, fair, balanced, uniform enforcement of the IP system. Now, just to finish briefly answering, Judge Braden's point, from the information technology industry side of things, just as a general proposition, you do get into the discussion of having a balanced system of IP rights with a copyright system, a trademark system, a design system, and a patent system that all work together. You benefit from enforcement that is strong, but also fair, that recognizes that there are many development models for information technology products now, whether in the software field, including open source softwares, in addition to proprietary models. In the hardware area, even their development models have become more complicated, with fabless companies and fabricators of hardware devices, all in this complex global ecosystem. And so for information technology, enforcement is important in a context of these very varied and global development, distribution, manufacturing, research models that are much more advanced than in the past, all bring us back to the beginning of the discussion that Mark focused on and others, which is the need for certainty, consistency, uniformity, to try and get everyone on similar standards around the world so that business, which is already global, can operate more efficiently and globally.
So tell us about how we're going to do this.
Well, I'd like to highlight some of the points here. Indeed, we think it's very important to structure not only an efficient protection of patent rights in Russia, efficient and fair, but we also would like to contribute globally in the protection of such rights and competition. in the area of the patent business, and we want such protection, global protection and competition to be fair and square. Well, if you take our companies, it is not always easy for our companies to explore new markets. Also in the U.S., where the Russian local companies face challenges. Although the patent system in the U.S. has been in existence for a couple of centuries and has been working efficiently, still our Russian businessmen face certain challenges, and these challenges are that it is not really simple for a company which invented something and received a patent on that. It is not easy to manufacture such products in the territory of the United States. Why? Because unfortunately, in terms of the enforcement of patents, there is the reverse side, when there is an abuse of patents. I already referred to patent trolling when some unfair competitors may attack a company. Well, large corporations have the opportunity and possibility to protect themselves. IBM, for example, I know invests a lot in just getting a patent and protecting the patent and such infringement. And companies sometimes apply for patents not to really produce or manufacture anything, but to protect themselves against such patent trolls. And I think that such companies do have such an opportunity, including IBM, but smaller companies, they don't have such a capacity to defend themselves, and they inferior in this respect. Although in terms of the universal fairness and in terms of the innovations, they would deserve protection, but still they may lose. Also, in the case of litigation, we're talking about very heavy costs, and smaller companies, although they might be right, they still don't have the capacity to protect themselves in court. Well, I mean, such challenges are not that topical for Russia as yet. The patent market has not been developed yet, and we again are happy, and I'm thankful to Ms. Novostolova and to you and to other experts who traveled to Russia. We are happy to have a discussion of the patent law, and such discussions become more frequent. Unfortunately, patent law was not paid much or any attention at all in Russia. Well, there was more attention and focus on copyright and trademarks, and patent law was on the sidelines, I would say, which is wrong, as we think, because patents would be the main driver for innovations, and we really like to see more attention paid to this. Still, we think that we can contribute to the solutions and challenges that face not only Russia but also other countries. By the way, the Skolkovo Foundation, together with the new economic school and with the help of the US experts, we made a project, and by the way, you can pick up a copy of a booklet, or rather a research paper, a book, both in Russian and English, where we lay out some of the approaches as to how we can improve the IP institution so that it would serve the purpose that we were discussing today, stimulating innovation, fair competitiveness and competition, and fair enforcement. We actually focused more on anti-monopoly regulation and intellectual property in our book, but of course there are other subjects that deserve discussing at an international level. And I hopefully that here we can be of use to each other. We see that an exchange of opinions is very important. in the Skolkovo Fund. And by the way, the Skolkovo Fund interacts with a number of companies, both smaller startups in Russia, which develop something from the scratch, and we also work with major corporations, which are our key partners, including Johnson & Johnson and IBM. And of course, we see that the approaches and needs of the companies, despite the fact that they are basically in the same business of promoting innovation, but their approaches are still quite different. That is why we think it is important to launch a dialogue and continue a dialogue to build a balanced IP system. I mentioned this a few times and repeated this many times, but the existing system of relations was established maybe 100 years ago. Much has changed since. And David also mentioned today that there is this new Invention Act of the US. It is geared towards trying to take into account the needs of today and take the internet and the norms of protecting the intellectual property which is related to the internet or on the internet. And again, quite a few subjects to discuss. We don't really need to think of the intellectual property protection institution as something really set and fixed. We need to develop this institution to have the norms of IP protection being dynamic and protecting the community. Thank you.
Judge Braden, if I could jump in very quickly.
Sure, absolutely.
What an insightful set of comments that was. I especially appreciated your discussion of patent trolls and non-practicing entities and litigation. Because as I think all of us have talked about, it is incredibly important to protect a system of innovation because companies will not invest or will invest more if they know that their investments will be protected, right? That is the virtuous cycle of protection with more innovation that gets protected, that funds more innovation, which benefits humanity at the end of the day through innovation. But make no mistake about it, litigation is a tax. And the way that a company thinks about it when we plan our financial spending, our algorithm, is that a dollar that's spent on patent litigation might be the very same dollar that would have been invested into R&D had it not been spent on innovation. So you are at a tremendous juncture, a crossroads, at a point where you can build a system that takes into account of asking questions about who should be able to enforce various patents, who are the real parties and interests to litigation, how do you protect downstream users of technology? And I talked about us being a big downstream user of technology. How do you protect them from avoiding that litigation tax while still protecting the rights of the inventors in a robust way? So I commend you on focusing on that issue at this stage in the development of your system, because I fear that we, at least in the United States, have gone far down a road without necessarily putting those protections in place.
I know this is a topic of great interest to Mr. Johnson.
Well, it's a topic of great interest not only to me, but of the United States Congress at the moment. Congress has held two hearings. The House Judiciary Committee has held two hearings, one specifically on the issue of abuse of patent litigation conduct, which is often referred to as troll conduct. I testified at one of those hearings, and I can tell you that the concern, I think that everyone who's looked into this is very worried about, is what happens when someone chooses to abuse the litigation system by bringing multiple actions against people who can't afford to defend the case. And so that they make many demands. There are people who have been making hundreds or thousands of demands in demand letters to people who are relatively unsophisticated end users who are being asked to pay some amount of money or face going to court, and the amount of money that they're being asked to pay is often less than the cost of just hiring a lawyer. And this has gotten a great deal of concern, and legislation is being written on that to be proposed as we speak. I can't tell you if it will be introduced by the end of May, but I think it will be introduced in that time frame. But we shouldn't confuse litigation abuse, which is what we're talking about with this situation, because that type of litigation abuse happens to be in the patent context, but it could be in any context. It would be no different than if you were leasing an apartment and someone started demanding that you get out of the apartment, or if you didn't, or pay them more money when they didn't own the apartment. And so this kind of litigation abuse is something I think the Congress will respond quickly to and effectively to. But the trick is to do it without discouraging people, and you mentioned this as well. If you have a small company here that develops a great invention, you should still have the right to be, and that invention is then infringed in the United States under a United States patent you've gotten, you should still be able to go to court without having to spend an unreasonable amount of money in order to stop that infringement, even if it's by a big company. And that we also want to preserve. So, because without preserving the rights of the inventor and in the inventing company, we will not have the system that we all need to have. And so that is the balance that we are working on. And Dave mentioned the post-grant proceedings that were established in the new law. That's another approach which has been taken with consideration in mind of the smaller company, the smaller inventor, of a way to not be burdened by patent claims that might come from others and have to go to federal court, which is more expensive. They can go less expensively back to the patent office if they think those claims are not good. But it's a very complicated area because you have a range of users. We have one patent system. It's a unitary patent system for all technologies, for all businesses. And you have problems at one end that are different than problems at the other end. And how much time you spend, how much money you spend, and where you make these important decisions is something you have to think very carefully about, because while a small inventor may have invested a small amount of money and you would think, well, let's decide quickly for them. On the one hand, you may have a company like ours or like Dave's where we frequently spend over $1 billion or more developing a single product that is protected by just one patent. And having done that, we want careful consideration to be given to our patent. We don't want it to be taken lightly and hopefully upheld, but if it's not upheld, we want to know there was a robust consideration of the issue and an intelligent, thoughtful consideration of the issues. Or else, I mean, and I'm not saying that just for us, if this is not available, then people will be very reluctant to invest $1 billion or more in doing some of the things that we need to get done. And I think we all would agree when we think about the diseases for which we don't have cures and many of the other things that we're working on, that as a world society, we have to do what we can to preserve the incentives for people to invest in solving these problems.
Thank you. We have reached the end of our time. I had promised to have questions, but maybe we can take one or two if there's an interest in the audience, because we do need to move on to let the room be used by another program. If not, we will all be available at the luncheon if people want to come and approach any of the speakers. They're here to answer your questions. Oh, we have somebody in the back. Yes, sir.
Здравствуйте, я имею один вопрос. Меня зовут Денис.
Good morning. My name is Denis Puchkov from Yekaterinburg. I'm an expert in protection of property rights in terms of criminal procedures. What is the situation in terms of the time required for appeals with respect to the patent? In Russia, there is no limitation to this effect. That is, you can do that within the entire course of 30 years. And if the patent will be found null and void, that would mean that it will be considered so starting the very first day it was issued. And that means quite a lot of companies and individuals could be brought to court of law and criminally persecuted. I know that in some jurisdictions there are certain time frames, and if it elapses, you cannot appeal against a patent. What are those time frames in your system?
Well, in the United States, a patent is found to be infringed. The district court issues a judgment. And typically speaking, if one of the parties wants to appeal, there's a very limited time period. I think it's 120 days. And you file just a piece of paper saying there's a notice to the Federal Circuit. And then after that, they have a schedule for the arguments, for the briefs and arguments. And typically it takes between a year and a year and a half to get a final resolution of that by the appellate court. Sometimes sooner, sometimes later. It just depends on the calendar. But they hear the cases in the order that they're filed. The Federal Circuit meets all year round. They don't take a vacation. You know, every single month at the beginning of the month, they hear arguments the first week of the month. And they're very prompt in getting their decisions out, usually within, 3-4 months, generally, unless there's an unusual situation. And then after that, there is a time period in the United States if someone wants to ask for reconsideration of the appellate court. It's rarely granted, but they can ask. If there's a question in which there's two different views of law within the circuit, some judges may have expressed in dissent, they can ask to have the whole court consider an issue, and that's been done 3 or 4 times a year, generally. And then the decision's final. Going to the Supreme Court in the United States is a privilege. You petition for the court to ask if they will hear your case. There's no guarantee. So the last word in the patent courts is our Federal Circuit, United States Court of Federal Appeals for the Federal Circuit. And if it goes to the Supreme Court, generally on a particular legal issue, that issue will be resolved within the next year. But each year, the Supreme Court of the United States here we will take 80 petitions. They resolve all of those at the end of the year, usually at the beginning of June or July. So they start fresh each year. So the time period between a trial, Dave may have, and Mark may have more experience in this. Typically in the United States, between the time you file your complaint and get a judgment from a district court, probably is in the range of 4 to 5 years now. Is that about right?
It can be as short as 3.
As short as 3, yeah. And you can go in to ask for an injunction right away, saying, stop, don't do anything. And that's a decision the judge makes without a formal procedure considering the merits of the entire matter. Those are rarely granted, but that's an option. And is that helpful to you? Is that a helpful answer?
I think he might have been answering.
К сожалению, я, может быть, неправильно...
Well, unfortunately, I was not that precise with the wording. What I had in mind, what is the period of time during which one can appeal against a patent to a court of law? What is the time since the time it is issued? Yes.
Okay. I understand what you're asking. Once a patent is issued now under the new law, you have a period of time, nine months, under which you can file a challenge in the patent office, which is what we would call an all-issues challenge. Any reason that you think the patent may be invalid, you can bring to the patent office. That is an expedited proceeding that would then take about a year and could be appealed, so that could be another year. After that period of time, which is the period for bringing a post-grant review, that's that type of challenge, you have an opportunity to bring another kind of challenge, which is known as an inter-parties review, for the life of the patent. So for all 20 years of the patent, you can bring this review. This review, though, can only be based on patents and publications that you think caused the patent to be invalid. Now, that's, in fact, the most common reason patents are challenged, but it's not all the reasons. It does not include situations where you think that someone previously invented it and did something public with it that didn't end up in a patent or a publication. But there is a life of the patent ability to challenge the patent. And in addition, if you are ever sued under a patent, you have the opportunity in defense of that lawsuit to challenge the validity on all issues again. So, and that happens through the life of the patent. And in terms of the impact of being sued, there are statutes of limitations so that if you are sued, the person who sues you can't collect more than 6 years of damages, going backwards more than 6 years from the time that you're sued. And if they win, I'm not sure whether this was part of your question, but if they win, it's not a criminal conviction, it's a civil matter, and the only remedies that are available are the award of damages or an instruction from the court telling you to stop doing what you're doing, that is the infringement. I hope that answers your question.
So we'll conclude, but I wanted to express my particular appreciation not only to the members of the panel, but to the Deputy Minister of Justice who is here in the audience, who helped plan everything, who is working very hard now on her BlackBerry. Thank you very much, and I hope we have an opportunity to meet with you again in another forum. Thank you.